Hey everybody, welcome to Startup Talk on Titan Radio. Nice to have you on board. We're broadcasting from Cal State Fullerton on the Fullerton campus. Our show is all about startups and entrepreneurship. And in the weeks to come, you'll meet folks involved in startups telling their story, as well as the people that help startups, their advisors, and help them get from the idea stage to becoming an actual company. By the way, for definition's sake, a startup is an entity that is looking for a solution to a customer's problem. They also need to understand who the customer might be. They need to figure out how they're going to make money, and they need to validate all of that. And then once that's up and running and they're starting to transact with revenue, then you could call them a company. I'm your host, John Bradley Jackson, and I teach entrepreneurship full-time at Cal State Fullerton. I'm also director of the Center for Entrepreneurship and the founder of two startup incubators, one in Placentia, California, and the other one in Irvine. Additionally, I'm the founder of Titan Angels, which is an angel investment fund. And my background is from Silicon Valley. I also did a tour on Wall Street helping companies go public, and this is kind of my third career. So you can follow us at the Cal State Fullerton website. Just search for the Center for Entrepreneurship, or you can find me on my website, johnbradleyjackson.com. And both entities are on Facebook, Instagram, LinkedIn, etc. So, by the way, Titan Radio is an official radio station. It's actually broadcast in 130 countries all over the world, and it's on air 24/7. So, doing some good in the community. So today, our guest is intellectual property attorney Justin Sanders. He's a vice president of the law firm Entralta. And it's fair, Justin, to call you an IP attorney, or would you want to be branded more specifically?
Yeah, I mean, IP attorney, intellectual property attorneys is kind of the general term, but technically I'm also a registered patent attorney, meaning that I've not only been licensed to practice in California generally, but I've also been licensed by the United States Patent and Trademark Office to prosecute patent applications, which not all attorneys are able to do if they don't have the requisite technical or engineering background.
So patent attorney is your core work, right?
Yeah. I mean, I would say about 60-40 patents versus like trademarks and other things. But so really any aspect of intellectual property we assist with, at least on what would be considered the transactional or prosecution side as opposed to litigation. So our firm doesn't handle actually suing somebody for infringement or defending someone that's been accused of infringement, but we'll handle anything and everything leading up to that point, even up to the point of providing infringement opinions, negotiating settlements, things like that. But if push comes to shove and a lawsuit has to be filed, that's where we would refer a client over to an actual litigation firm that's got the manpower.
We're going to have to define a lot of these terms.
Happy to do so.
But let me just throw it out there. So what is intellectual property kind of in a nutshell?
Yeah, so in a nutshell, I mean, intellectual property is really just any work product or creation of the mind, if you will. So, I mean, anything that you come up with is potentially protectable through some form of intellectual property or another. So the big categories are patents, trademarks, copyrights, and trade secrets. Those are kind of the big four that fall under the umbrella of what we call intellectual property. In a nutshell, patents are the mechanism that's used to protect inventions, essentially, or ideas to some degree. Trademarks are the way to protect the brand names or the source identifiers that are used when you're actually selling those products or those services in the marketplace. Copyrights are a way to protect expressions of ideas rather than the ideas themselves. So I won't muddy the waters too much, but copyrights typically are used to protect things like songs, movies, books, photos, artwork, things like that, creative expressions. And trade secrets are used to protect confidential information that a company might have that gives them some value over their competitors. So the common example would be the Coca-Cola recipe would be a trade secret, but it could be things as simple as customer lists, other things that you just have within your company that you consider to be proprietary. Could be protectable as a trade secret. So clients come to us, people come to us, they tell us what they've developed, and then it's our job to kind of figure out what's the best way to protect those things, whether through patents, trademarks, et cetera, or sometimes it's a combination of more than one of those things.
Cool.
Yeah.
So all of those are appropriate for a startup.
Oh, yeah.
And I will admit that most of the startups that we encounter in our incubators, in my work as a startup advisor, start with an invention, and the question is, could I protect it, and could I get a patent? Mm-hmm. And yet there are many types of patents.
There are. They can be kind of boiled down in most cases to two main types. They're what we call utility patents and design patents. There is a third type called a plant patent, where if you're developing plants, asexual producing plants, you can get plant patents, but that's not really something I do. So most people are looking at either utility or design patents. In short, utility patents protect essentially the way an invention functions, as the name implies, the utilitarian features of an invention, whereas design patents protect the way an invention looks. So if you're selling some kind of hard good, typically, if it has a unique look to it, you could potentially get a design patent that protects the look as opposed to the functionality. And sometimes inventions are potentially protectable through both utility and design. And again, that's something we help our clients with, is figuring out what are the potential options, what's viable, what's not, and help guide them down the right path.
So what are the basic steps to get a patent?
So the first step is just discussing generally what a client's come up with, because we want to see if it's unique enough. I mean, in short, when you're applying for a patent, the patent office is essentially going to look and determine whether or not your invention is sufficiently unique compared to anything that's come before it. So what they're looking at is really anything that's out there in the public, whether it's been patented or not. It could just be something that's been published online, something that's been sold. Anything out there that predates your application filing date is what we call the prior art. And so what the patent office does is when we file an application, they analyze it, and essentially what they're doing is they're trying to determine whether what you're trying to get a patent on is sufficiently unique compared to any prior art that's out there that they're able to find. And so, I mean, the technical standards is what we call novelty and non-obviousness, but we don't need to go too far into detail on that. Again, that's something where we kind of discuss those issues with the client at the outset to see, okay, well, is this something that's potentially patentable? Is it sufficiently unique? Sometimes just based on our general experience or things that we've seen out there, or sometimes even things that the client has seen out there as far as what competitors are doing, we're able to kind of come to a general conclusion, at least what we think their chances might be as far as overcoming those hurdles of novelty and non-obviousness. Other times there is the option of performing what's called a patentability search, where we do some searching through patent databases in the U.S. and elsewhere in other countries to see if we can find anything that might come close to a client's invention before they spend the money on filing a patent application. Because again, ultimately that's what the patent office in the U.S. or in other countries is going to be looking at, is whether your invention is sufficiently unique. And how they also look at is, maybe there's certain aspects of an invention, some narrower aspects where there might be some uniqueness that could be patentable. So if someone is able to get a patent, that doesn't necessarily cover their entire invention, but sometimes it only covers certain aspects of their invention. So they might be selling a widget that has 10 different features. Maybe 8 of those are already out there in the prior art, but maybe 1 or 2 of those is sufficiently unique enough to be deserving of a patent. And so sometimes patents are narrower than they may appear on the face of a patent. And that's something we have to talk through with clients on as well, is when they might come across what they think is a patent that covers what they're doing, but then when you look at what's called the claims of a patent, which is the part of the patent that really defines the scope of protection, that patent might only cover a subset of the features that are actually shown and described in that patent. And sometimes that's enough to warrant pursuing that patent for a particular company. If what they've developed, if those narrower features truly makes it a better product compared to what competitors are doing, and it's enough to give them an edge, it could be enough to provide that value for them to move forward on pursuing a patent, even if it's narrower than they may prefer it to be.
Yeah, so when referring to my question, the steps, well, the first step might be to have a preliminary discussion with the patent attorney.
Right. And so after we kind of have that discussion and figure out, okay, is there something here that's worth pursuing? And that's the key, is it worth pursuing? Because if maybe, depending on the situation, depending on the client and what their ultimate goals are with this invention, they might determine, well, this potential patent is far narrower than what I'd be interested in pursuing, and they might just decide to walk away at that point. So it's having that kind of realistic conversation on, okay, is this worth investing the money to actually pursue a patent on? And there's a lot of different reasons why it would be worth it. But if they come to that conclusion that, yes, it's worth it, the next step is for us to prepare and file that patent application. Ultimately, in order to get a patent, at least on the utility patent side, you have to file what's called a non-provisional application, and that's the full-fledged application that gets examined at the patent office and could ultimately result in a patent. There is a preliminary step that could be taken. It's called a provisional application, and I'm sure a lot of people are familiar with that phrase. And essentially what that means is it's essentially a formal invention disclosure that you submit to the patent office, and it basically holds your place in line for up to a year, meaning that once you file your provisional, you have 1 year from that date to follow up and file the full non-provisional application. If you don't do it within that year's time, you kind of lose that filing date. So in other words, if you do file the non-provisional within that 12-month window, the non-provisional gets backdated and it's given the same filing date as your provisional. So it's as if no time is lost. And the benefit there is, again, what the patent office is looking at is whether your invention is unique compared to the prior art. And the prior art is based on your filing date. So meaning that the day you file your application, that's the day that the universe of prior art gets cut off, meaning that if someone publicly discloses your exact invention the day after you file your application, it won't count as prior art against your invention or against your patent application. So in other words, the earlier you file your application, the better your chances become in most cases. And so filing that provisional, kind of locking in that filing date as early as possible, is going to increase your chances potentially of being able to get a patent at the end of the process. So when people say that they have a provisional patent pending, it doesn't mean a whole lot, except that they've started the process, but they don't have any enforceable rights or anything until they file that non-provisional, and then until that non-provisional actually turns into a patent if it passes examination and everything. So the patent application gets filed, whether it's a provisional or non-provisional. Once that non-provisional is filed, it gets put in queue for examination. So there's a bunch of examiners at the patent office. They each have their own specialties. So they're in what's called art units. So there's different art units for different kind of technological backgrounds. So all that's to say is that the examiner that gets your particular application is going to have at least some amount of experience in that particular industry or in that particular technology field. They will then review the application. They will perform a patent search looking for any prior art that might be out there that reads on or that teaches what you're trying to claim in your patent. And then if they find things, they will issue what's called office actions, where they might reject one or more of your claims. And then at that point, we have the opportunity to have a dialogue with the examiner to try to overcome the examiner's positions, either through amending the claims to better distinguish over the prior art, or sometimes the examiner is just plain wrong, and we nicely explain why they're wrong, and ultimately work towards that what's called a notice of allowance, where the claims are now deemed allowable or patentable in light of the prior art that's been cited. And then after that, you pay an issue fee, and then the patent office will give you the patent.
And it's my understanding this can actually take a fair amount of time. One is because of the backlog of the patent applications, and then because of the back and forth that happens between the attorney and the Patent and Trademark Office.
Yeah, and so it's gotten better. The backlog, like when I started about 12, 13 years ago, it was quite a bit of a wait, particularly like in the software technology spaces where you could be waiting upwards of 3 years from filing the non-provisional before you get a first response. 3 to 5 years is sometimes what we would tell clients back then. But they've hired a lot of examiners since. I think they've kind of streamlined the process a bit more. And so now the average wait time from the date you file your non-provisional application until you get a first response tends to be about 18 to 24 months, which is still quite a bit of a wait. But they also have ways to speed up that process. Specifically, that they call it track one examination, where basically you pay an extra fee to the patent office. Surprise, surprise.
Sweet.
Give them a little more money, and then they will fast track the application. So rather than waiting 18 to 24 months, you end up waiting about 3 to 4 months to get that first response. And with the track one, they try to complete the entire examination process within 12 months, meaning that within 12 months from filing, you're going to get a yes or no answer, basically, as far as whether you're going to get a patent or not. So it's a much shorter back and forth with the patent office. But if you're on that normal track, it's going to be typically 18 to 24 months. It could be less, it could be more. It's, so simpler art units, they have examiners that aren't as backlogged. So like mechanical devices tend to be on the lower end of that wait time, sometimes even less than 18 months. Whereas the more complicated technologies, software and things like that, could be on that higher end or sometimes even longer. And there's also other ways to fast track to some degree. Like if you have at least one inventor that's 65 years old or older, you can file a petition to basically expedite it. Not as quickly. You're not going to get a response within 3 months, but maybe closer to 6 to 12 months, you'll get a first response. Or if you have an inventor that has a health condition where they might not live to see the end of that process,
right,
which it is kind of laughable. I actually just recently had a client that fell into that category, though, and we got a first response within about 3 or 4 months with that one. And those, if you file the petition based on age or health, that's a free petition that you file. You don't have to pay an extra fee to the patent office or anything. And so anytime that's an option, we always take advantage of that, too.
Did not know that.
Yeah.
Let's back up just a second. So many of the startups that I encounter know enough to do the provisional patent application, and that's the good news. But most, when you dig in, well, we did that, was it a year ago? No, I think it was actually 18 months ago, and it's expired, correct?
Yeah.
So you touched on it, but what are the remedies in that case?
So, I mean, there really are no remedies, unfortunately. I mean, so the thing that you're working against, one, you're working against the prior art, meaning you don't know what other people might be doing in the same industry, whether they're coming out with a similar product, what they might be publicly disclosing. So it's kind of a race against that clock where you want to file as soon as you can. The other thing that you're up against is your own potential public disclosure. So if you are looking to take your product to market, launch it, or just start talking about it to potential licensees or purchasers, et cetera, all that activity counts as what we call public disclosure. Now, where that factors in is in the U.S. there is a grace period where if you do publicly disclose before filing a patent application, you've got 12 months within which time you can still file your application in the U.S. and you're going to be okay, at least as far as your own public disclosure. If you publicly disclose and you wait more than 12 months to file that application, meaning if your application has a filing date that's more than 12 months older than your first public disclosure date, you're basically out of luck as far as what was publicly disclosed. So in other words, your own public disclosure that's more than 12 months old will count as prior art in determining whether your invention is unique. Now, that's only the rule in the U.S. Canada and Mexico kind of have similar rules, though I don't believe they're as forgiving as the U.S. They're a little more narrow as far as when those grace periods are afforded. But outside of North America, the general rule is that you have to have an application filing date that predates any public disclosure. So even if you publicly disclose just the day before you file your patent application, you're now out of luck outside of North America. And with that said, I mean, without getting too complicated, I mean, there's ways of stringing applications together such that you can file in the U.S. first, and then within a period of time you can file internationally as well. And so the rule of thumb is at least get your U.S. application filed before any public disclosure takes place. And that way you can keep all of your options open. But so in your hypothetical, though, if someone files their provisional application and then they start taking their product to market after they file their provisional, if they aren't able to get that non-provisional filed by that 12-month period of time, then once they do file the non-provisional at some point down the road, 14 months or whatever, that non-provisional is going to stand on its own filing date. It won't be backdated. So then what you'd have to look at is, okay, well, if this non-provisional is going to stand on its own filing date, when was your first date of public disclosure? And if it was more than 12 months prior to that filing date, the non-provisional, then you're basically out of luck, at least as far as, again, whatever details were actually publicly disclosed or commercialized at that time. And that's something else that's important to point out is when we say public disclosure, it's not just the things that are publicly viewable by consumers or the public generally, but any commercialization of technology is also considered a public disclosure of that technology. So I say that like in the software context where you're selling a compiled application to somebody to install on their computer and run, that typically that user is not going to be privy to the source code that's running behind the scenes. And if you're getting a patent on software, usually it's those underlying algorithms you're getting patents on. So you would think, well, no one's actually seen those algorithms, so I didn't publicly disclose them. But that's not true. The laws basically say that if you're commercializing those algorithms, that's considered a public disclosure. So yeah, rule of thumb is file an application, whether provisional or non-provisional, before any public disclosure takes place. And if you do file the provisional first, make sure you're filing that non-provisional within that 12-month window.
And this is a tricky issue with startups because in the early stages of the invention, they're still trying to figure things out.
Sure.
And in fact, talking with prospective customers is how you validate that they are the customers,
Yeah.
and they really do have that problem, and it helps you ultimately create the feature set that you're going to solve. Does that constitute disclosure?
Yeah, in a nutshell, yeah. I mean, if you're talking to prospective purchasers and you're disclosing the details that you would ultimately be trying to get a patent on, and those prospective purchasers have not signed a non-disclosure agreement or anything like that, then that would be technically considered a public disclosure for patent purposes.
So one thing I know that the folks in my world would say, and this you may now cast this down, is that it's okay to say what your solution might do. You just don't describe how you do it.
That could very well be a viable strategy. It really just depends, though. I mean, it depends on what or how broad of a patent you might be able to get, or what features you're actually trying to get a patent on.
Yeah.
So yeah, oftentimes it is more of the not necessarily what your product is, but how it's doing what it's doing, and it's those how details that we try to get a patent on, and it's typically not those how details that you're telling a prospective customer. You're just saying, we're going to do a widget that solves this problem, or we've got a widget that solves this problem, but we don't necessarily tell them how we solve it. So depending on what you disclose, or what you might be able to get a patent on, that could be viable. But I've got other clients where, I mean, the thing speaks for itself, if you will. Like I've got a client that sells slings for beverages that's got a bunch of different pockets and other features and things like that, where if you just tell somebody, hey, I've got this beverage sling I mean, that's basically what we'd be getting a patent on, are those features. Whereas like on the software side, things like that, you could get away with that type of kind of general disclosure without actually disclosing the secret sauce that you'd be getting a patent on. So again, like in the software context, when you're saying we've developed software that solves this problem, that type of statement is typically not going to create the kind of prior art that would prevent you from getting a patent on those particular things, because again, you're not disclosing the underlying functionality. But it's really just case by case. But I mean, definitely, if someone is willing to sign a non-disclosure agreement, I always advise clients to get them to sign, and I always welcome them to just blame their dumb attorney for forcing them to have everybody sign an NDA before disclosing. But I mean, with that said, it depends on who you're talking to. If you're talking to VCs or people like that, oftentimes they're not willing to sign NDAs, and so that's the beauty of the provisional application, though, where you don't necessarily have to have everything figured out at that point in time. You file a provisional on the universe of details you currently have figured out, so you can lock in patent pending status on those details, and then you use the next 12 months to test the market, to add new features, to further develop things, and then you can throw all those additional details in when it comes time to file the non-provisional. So, and because the provisionals, they're just a placeholder, they're not examined, there is no specific format or requirements as far as how the information needs to be presented. The information just has to be in there. So it's definitely something where startups can prepare their own provisional as long as they make it detailed and robust enough to then later support that non-provisional, but they can save themselves a lot of money. The filing fees, I mean, most startups are going to probably qualify as what's called a microentity, which means they get a 75% discount on all patent office fees. And so if you're filing as a microentity, filing fees, I want to say they're like $70 now for to file a provisional. So it's a drop in the bucket compared to the amount of protection you're potentially giving your company and the potential value you're preserving there to later pursue patents on some of those features. So file a provisional first before you disclose is always a prudent thing to do.
So I can confirm, as an angel investor, I will not sign NDAs.
Yeah.
And the reason is I get so many
exactly
ideas, and some of them highly overlap. And I would argue that as an investor, as much as I want to understand the opportunity, I don't really need to understand the source code. I just need to know what it's going to do.
Yeah.
And is the idea going to scale, right?
Yeah. And it depends, like I said, on who you're talking to, and oftentimes those initial conversations are going to be very high level where you're not getting into those details. But as you get further down the path with a potential investor, let's say, or licensee, then you might start disclosing more details. And then at that point, it tends to make sense for both parties sometimes to sign like mutual NDAs, if not like a one-way NDA, before you really start getting into the details. But typically, that's not something you necessarily have to do for that initial conversation. But yeah, that's the primary reason why most VCs and angel investors don't want to sign those things, is because they don't want to have to deal with receiving similar ideas from different people and being accused of breaching their NDAs.
Right. Now, you use some terms earlier that we might want to define for our audience. So up to now, we're talking patent prosecution. Is that correct?
Right.
So what is that exactly?
Yeah, so I mean, prosecution, most people, when they hear that term, they think like criminal law, the prosecutor. But prosecution is just the term that's used when you're actually putting forth either a patent or a trademark application before the Patent and Trademark Office and trying to push that through the examination and obtain a patent or a trademark. So that process of filing an application and working with the Patent Office to try to get that patent or that trademark is called prosecution. But it's basically just all transactional work. So meaning we're preparing the patent application, which is a written document. We're filing that. There's going to be back and forth paper responses between us and the Patent Office. And so that whole process generally is called prosecution. And again, compared to litigation, which is all the stuff where if someone's being accused of infringing a patent or a trademark or a copyright, let's say, or trade secret misappropriation, any kind of lawsuit basically would be litigation, and that's the aspect that we don't handle. So we're solely on the prosecution side of things.
And more definitions. So in this case, infringement, that means people are using your idea without your permission.
To boil it down, essentially, yeah. So on the end, there's different standards, whether you're talking patents, trademarks, things like that. So I mean, as far as patents go, infringement basically means that someone is making, using, selling, offering for sale, or importing an infringing article in the United States. And I say United States because every country has its own patent system. And so if you want protection in a particular country, you've got to file an application in that country and get a patent in that country. But most of our clients are happy just with getting a U.S. patent because the U.S. tends to be the biggest market for most goods and services, at least for our clients. Europe tends to be second biggest, and so a lot of clients go for protection in Europe as well. But you're looking on a country-by-country basis, but it also, again, it covers people that import goods into that country where you have a patent. So if someone's making knockoffs in China, they would not be able to import them into the U.S. if you have a patent in the U.S. And if you had a patent in China, you could stop the knockoffs at their source, and that's a strategy we often explore with clients. But yeah, so what you have to look at, though, is not just, as I mentioned before, a patent could describe a bunch of different features in what's called the specification part of the document, but really the scope of the rights afforded by a patent is in those claims. It's basically the numbered paragraphs at the end of a patent document. And so the document itself could describe features A through Z, but when you look at the claims, maybe it's only A, B, and C that the patent really covers. And so oftentimes we do get clients that come to us saying, oh my gosh, look at this patent. It talks about everything. And but I thought I know this one feature has been around for 30 plus years. How could they get a patent on it? And then you would look at the claims, they don't have a patent on some of those features. It's some of the newer features. And because of that, then oftentimes, while it's kind of discouraging to see a patent on technology that you're or in an industry that you're already in or similar to your product, when you actually look at the details of that patent, look at the claims, typically the claims are going to be narrow enough to where there's going to be some kind of workaround, hopefully, either already that's embodied in your product or something that we can now incorporate into the product to get around these claims, depending on how crowded the field is. That's potentially an option, but you always want to look at those claims to see what the patent actually covers. And even there's a lot of wiggle room sometimes that we kind of work with clients on to figure out. But it's a very complicated issue, the issue of infringement, and it's not as complicated for design patents. It's a different standard, but yeah, I mean, ultimately, you just kind of have to look at the details of those claims for utility patents to see what's actually being covered there.
Yeah, one thing, my experience with patent attorneys is they have further specialization by industry category.
Yeah.
Do you have such a specialization, or?
Well, I mean, being at a small firm for pretty much all my career, most of the inventions that come through the door tend to be like mechanical, things like that. So I've got, just based on experience in practicing law, in patent law in particular, I've got a lot of mechanical experience now. Technically, my background is computer science, so I've got a bachelor's degree in computer science. All it's to say is that I'm typically a quicker learner when it comes to software-based inventions or just computer-based inventions generally. But at my firm, I basically handle anything that's mechanical, anything that would be considered high-tech, computer hardware, software, electrical. But again, it could be as basic as, like I said, I've got the client that sells beverage slings for bottles and cans, things like that. So a lot of just consumer goods that we handle as well. And so the other attorneys in my firm, they handle more of the kind of life science areas, so pharmaceuticals, things like that. Though even with that said, I handle a lot of medical devices as well. So, I mean, in this field, it's rare for an attorney. I suppose at bigger firms, you might get a patent attorney that only handles like a very specific area, but most of us handle kind of a range. And the reason being is, I think once you have that kind of engineering or technical background, it tends to be relatively easy for us to pick up a new technology. And in most cases, the clients are going to be the experts in their field because, I mean, presumably they've invented something that's never been seen before. So no one's going to know more than the client. And so we typically then rely on the client to educate us a little bit. And then we kind of educate ourselves as needed if we're not necessarily completely familiar with the field. But again, I mean, I consider myself a quick learner, but I would say anything mechanical, high-tech is kind of within my wheelhouse at this point.
Got it.
Yeah.
And then it's my understanding, correct me if I'm wrong, that in Entralta and in the case Justin Sanders, you tend to specialize on startups and small emerging companies.
Typically, yeah. So, I mean, I would say that's probably about 90% of our client base would be startups and individual inventors, smaller companies, though we do have a handful of larger companies as clients, some universities and research institutes. But by and large, startups and independent inventors, which is why we charge flat fees that are competitively priced, just because we kind of cater to the startup shoestring budget, and we don't want to break the bank before they even get out of the starting gate.
So, in fact, I think it's my understanding most of your competitors, the other IP firms, charge by hourly rates. Is that correct?
A lot of them do. I mean, admittedly, I think more and more are going the way of flat fees, like we base our fee schedule on. But I mean, the very big firms, that's all hourly. We're what you call a virtual firm, meaning that we don't actually have like a physical office space. We just work out of respective home offices. So if on the rare occasion a client actually wants to meet with me face-to-face, I either go to their office and meet with them, or if we can go to a coffee shop, or Cal State Fullerton Incubator has been kind enough to allow me to have office space there when I need it to meet with clients. But I would say I probably never meet 90% of my clients in person ever, just because they're in other states or other countries,
Really?
or they're just too busy to meet in person. And I mean, with technology being what it is now, with email and phone, obviously, where you can send documents, you can have Skype conversations if you need actual FaceTime. It's just most clients would prefer not to, and then they appreciate the virtual setup where we don't have a ton of overhead that we have to pass along to our clients in fees. So it gives us the flexibility of charging reasonably priced flat fees. I don't bill for phone calls and emails with clients, so they never have to be scared to call me to ask me a question. We don't have junior associates. So anything that I'm handling, it's me handling it personally. I don't hand it off to a junior associate to cut their teeth on. But yeah, so it's we run lean and mean like our clients, we like to say.
Yeah, cool. I love your business model. Let's flip the conversation a bit. Let's go back. You're 12 years old. Did you think of yourself becoming an attorney? How did you get there?
Yeah, not at all, actually. So yeah, I'm not the type that grew up wanting to be a litigator or an attorney generally or anything. Actually, I went into undergrad. So I did my undergrad at Cal State Long Beach, and I went in undeclared. And I think it was like during the orientation week, they're kind of exposing us to different majors and career paths and everything. And I said, oh, well, software sounds kind of cool. I like to play video games. I like software. I'll go check that out. And so that's the major I declared, and that was back in early 2000s. And so about halfway through my undergrad is when kind of the dot-com bubble burst and jobs started going away. And at Long Beach, it's like you could either work for companies like Boeing or other defense companies, or maybe some startup software company, but there wasn't a whole lot of opportunities, at least coming out of Long Beach State. So we started looking at other opportunities, and one of my classmates had a friend that was in law school, and he was also a computer science major, and he was telling me that, well, law schools, just like universities, generally like to have a diverse student body, and most law students have political science, philosophy, English, history degrees. So if you go in with something as unique as computer science, it kind of gives you a leg up on other people applying. Plus, you're able to then be a patent attorney and practice intellectual property and all that. So I started looking at those options and saw how niche of a field being a patent attorney is. As I mentioned before, it's if you don't have a technical or an engineering background, you can't even sit for what's called the patent bar to be a licensed patent attorney. You could do trademarks and other things, what we call soft IP, but you can't prosecute patent applications without that technical background. So I figured, well, this is a way to give me an edge on other people applying for jobs generally, and might give me a leg up. And so I started looking at that career path at that point. So that happened, again, like sophomore, junior year of undergrad is when I started looking at law school as an option. And then started looking at law schools, and Whittier Law School at the time back then was one of just a handful, literally a handful of law schools that offered a separate certificate program on intellectual property. Like even some of the bigger schools were just offering like a single course that they called intellectual property. But Whittier had a separate class for patents, one for trademarks, one for copyright. So it really gave me a lot of experience, a lot of knowledge across the board in intellectual property. So because of that, I decided to go to Whittier after graduating from Long Beach State. And about halfway through law school, I think after my first year, I sat for the patent bar, because technically that's another thing. There's what's called patent attorneys, and then there's patent agents. And so both groups have to sit for the patent bar. But technically all you need to do to sit for that is have that technical or engineering degree or background. So people that never go to law school, they could still become patent agents if they want to basically prepare and file patent applications. Now, that's basically what they're limited in doing. They can't do any other legal work like drafting contracts or anything like that, suing people, things like that. But there's a lot of patent agents out there. But then so I became a patent agent after my first year of law school, and then I was able to start actually working as a patent agent while finishing my time there, and then sat for the California bar and became a patent attorney. But yeah, so it definitely was not ever the type to think I'm going to be an attorney when I grow up.
Right, but in reflection, when you were young, were there personal characteristics or skills that you had or were developing as a young man that in reflection contribute to where you're at today? You said video games, okay?
Yeah. So much self-reflection here. Well, I mean, I would say that definitely I've always been kind of analytical, and certainly going through the computer science program helped with that, because, I mean, learning how to develop algorithms and these procedural steps and all that kind of stuff, and thinking, okay, how are things need to be structured to make this work? So having that analytical mindset, I think, certainly helped. Yeah, I've always fancied myself. I think I've always been a smart kid.
Smart kid, a little bit of a geek, maybe?
Oh, definitely. Yeah.
But you were good at math and science by chance?
Definitely science. Math I kind of struggled with, which was the ironic thing with computer science, because about half the coursework is like advanced physics and linear algebra. I liked linear algebra, but calculus was never my strong thing. I mean, I got B's in calculus and stuff, but wasn't ever my favorite subject. But yeah, science definitely. I've always been a fan of science and good in those areas. Yeah.
So in my case, I was president of the bowling club in high school, which of course has had many significant returns as in my adult life.
Sure,
But enough about me. So let's go back to the prospective client, the startup. What are some of the rookie mistakes that you have witnessed by startups when it comes to IP in general?
Yeah, so I mean, some of the big ones would be, again, filing a provisional is something that many startups are able to do as long as they do it right. Again, the key is making sure you have as much detail in those provisionals as possible, meaning that if it's just like a one-page kind of boilerplate list type of submission, that's typically not going to be enough to for that non-provisional to later claim priority or be backdated. So in other words, in order for that to happen, it's not simply enough for you to file that non-provisional within that 12-month window, but that provisional has to be detailed enough, meaning that everything you're pursuing in that non-provisional had to have some amount of disclosure or support in that provisional. So if the provisional is lacking in detail, you're not going to get that earlier filing date. Your non-provisional is going to stand on its own filing date. So that tends to be one of the big mistakes I see being made, is those provisionals aren't detailed enough. So again, anything and everything that you can think of to throw in those things, better to be over-inclusive rather than under in most cases. Now, I mean, one caveat is if you have something where you might be considering keeping something protected as a trade secret, leave that kind of detail out, but everything else just throw into the provisional, and then that way we've got more details to work with when it comes time to file that non-provisional. So that's a big one. Another one is when people try to file their own non-provisionals, which it's not the most difficult thing in the world to get a patent if what you developed truly is unique. But the problem is that the claims you end up with might be far narrower than what you could have gotten. And again, the issue of infringement is not whether someone has a product that is covered by the general description of your patent, but rather whether they have a product that reads on the claims of your patent. So you may have been able to get a claim allowed that covers A, B, C, D, and E, but if somebody found a workaround that only incorporates A, B, and C, that's a potential workaround that's non-infringing. And so I have from time to time have had new clients come to me where they've already filed their own patent and obtained it, and now they see a competitor basically doing what they're doing, and then I look at the claims, and unfortunately I see that the claims are so narrow that what this competitor is doing is actually a non-infringing workaround. So I always tell clients that if you decide that it's worth spending the money to protect something, then it's worth spending a little extra to make sure it's done properly. Otherwise, your patent's not going to be worth more than the paper it's printed on. So that's another big mistake I see sometimes. A third one that I see oftentimes is not having the chain of title figured out for things as you're developing. So if, let's say, again, if you're in the software space, you hire some independent contractor to actually implement some software idea you need to have an agreement with that developer that basically says anything they create on your behalf, they agree to assign all right, title, and interest. Basically, they agree to assign ownership over to you. Because if you don't have that type of agreement, you would think, well, I'm paying this person to create something for me. That should mean that I own it, but that's not always the case. And this varies from state to state, but in a state like California, if you don't have an express assignment agreement, oftentimes what happens is you as the quote-unquote employer or the person who compensated this either employee or an independent contractor, you're given a license or a shop rights basically to commercialize or to use that technology, but you're not the owner, meaning that developer could turn around and license that same stuff to somebody else if they wanted to. So having that type of agreement in place is key, and preferably you want that type of agreement in place before you actually jump into the relationship and have the work begin. And that goes for whether someone would be considered an independent contractor or an employee. Again, it varies from state to state, but most California courts like to see, even in an employment agreement, have some kind of express language where anything they create, they agree to assign over to you, the employer. And again, if you're a startup that's looking to get funding or be acquired, before any of that actually happens, before these licensees, these other bigger companies are going to do their due diligence, and one of the first questions they're going to ask is, do you have clean chain of title to all this, or what's the chain of title for all this? Show me from conception to current ownership the documents that show that you as this startup company actually owns all of this IP. So yeah, that's probably one of the biggest mistakes I see being made.
So let's flip it from mistakes. So could you describe a patent success story that you were involved in that you know personally?
Yeah,
that you're at liberty to talk about.
yeah. I mean, as far as like cool stuff, because I see, I mean, there's definitely stuff that puts you to sleep, and then there's other things that are cool. And I mean, it's obviously cool for each client, but as far as like what most people might be interested in, I mean, we handled one for a client that they ended up. It was basically a batting weight, and I know I've shown it to you before. But
baseball bat
for baseball bats, where the traditional batting weight would be like a donut that kind of sits at the end of the bat. And we had a client that figured, well, that traditional batting weight kind of throws off your natural swing, having all that extra weight at the end of the bat. So he developed a more low-profile weight that would sit right at the center of mass of the bat. That way it added weight without throwing off the actual balance or throwing off your natural swing. And they sold it under the name Hitting Jacket, JACKIT. and they ended up licensing that to Major League Baseball. It was, at least at the time, one of only, I think, like 20 products to be licensed by Major League Baseball. So we helped them to get protection on that. And then, I mean, I've got clients in all industries. And again, I mean, success is kind of just depends on a particular client. Like sometimes success is just getting a patent to add value so that you can be acquired by a company, where other times the goal is to get a patent so you could stop your competitors if you plan on taking this product to market yourself. So like in that space, I have a client that developed or continues to develop orthopedic braces, like back braces and things like that. And we were able to get a patent on one of their more popular braces that they've been able to use now to successfully stop 3 or 4 competitors from knocking off different aspects. But yeah, lots of success stories. Not all I can talk about, as you said, but really, yeah, in all different industries. I've done things for toys, remote control cars, all the way to one time I did an application on like a device that used fast neutron bombardment to detect explosive devices.
I have some at home myself. Yeah.
So yeah, I mean, it really it spans the whole spectrum. But that's one thing that keeps a job interesting, though. Yeah. And I think that's one reason why I like being at a small firm, is aside from being able to kind of work directly with clients and have this kind of educational relationship where I'm able to kind of teach them all these different things so they can then know when to talk to me, know the right questions to ask. Yeah. But it also kind of helps me work in a number of different fields.
Yeah. In fact, on that note, we touched on it, but how soon, if you have an invention, should you reach out to the IP attorney?
Call me today. I mean, really, it's sooner rather than later is what I always say. And it's not uncommon for people to contact me too early, but better to do that than to be too late. And so I'll tell clients, you know what, it sounds like you still might want to develop these particular aspects further. So just keep me updated, circle back with me when you have more to tell me, and we can kind of keep a continuing dialogue. But again, the sooner you have, or as soon as you have something that you think you might want to pursue a patent on, better to have that conversation so that you can at least rule out the option of patents if it ends up not being a viable option for one reason or another. But better to have the ability to make that decision rather than the decision being made for you, where if you wait too long, you could be out of luck, whether some competitor comes out with something first or your own public disclosures prevent you. Yeah. So yeah, I'm always happy to have those conversations, though, and even if it's too early stage, better to kind of figure out what you got and what you might develop further. And so I would say, as a rule of thumb, though, before you take something to market, at the very least, before that point, you'd want to talk to a patent attorney to just see what options there are there.
Yeah. So we just have a few minutes left. Is there anything that I didn't ask you, or is there anything you'd like to say that we haven't covered that you think our audience would want to know about?
No, I think we covered quite a bit. Again, I mean, just generally speaking, at least for myself personally, I'm always happy to have these conversations. I don't charge for initial consultations, so don't be afraid to contact me if you want to talk through an idea. Or again, patents are just one aspect. Every company has a brand name at least. And even if you don't think you want to spend the money to get a federal trademark registration on your brand, at the very least you want to make sure you're not infringing anyone else's trademarks. So at the very least, every company has a trademark issue. So I think it's prudent for really any startup or any company generally to at least have one conversation with an intellectual property attorney. And again, I'm always happy to have those conversations.
Cool.
Yeah.
So you've been most generous. How can we help you?
Well, I appreciate you having me on the show, definitely. And again, just keep me in mind, as I know you're definitely involved in the startup community, the entrepreneurship community. So just feel free to send people to me when they have intellectual property issues.
And then how might our listeners contact you?
Yeah, so best way to contact me would be either by phone, which my direct number is 949-250-5800. Again, 949-250-5800. Or you can email me directly. It's my first and last name, so justin.sanders@entralta.com, and that's ENTRALTA.com. or you could just visit our website. But again, we don't have junior associates or paralegals, so anytime you have a question, you're going to be speaking directly with me. But always happy to talk by phone or email, or in person if you actually want to see me.
All right, very cool. Well, thank you so much.
Yeah.
For our listeners, be sure to visit the Fullerton website for the Center for Entrepreneurship, or my site, johnbradleyjackson.com. Our guest next week is a branding and digital marketing expert, Ryan Fratsky, and he's going to talk about how you develop a brand and promote it in the complicated digital realm. So with that, we'll see you next week at Tuesday at 1 o'clock, and appreciate you coming by today, Justin.